carried him. So he cannot be blamed for the inefficiency of process that are falling squarely at the hands of the prosecution. They even have his phone, which they took. If they've not processed that phone, find out the telephone number on the phone, surely, that cannot be used against the accused person. There's the allegation, Your Honor, of that he will interfere with witnesses. Your Honor, the answer to that is very simple. I'm so sorry. There's an allegation that bail should also be denied because he is likely to interfere with witnesses. Your Honor, first of all, we've not even been given a copy of the charge sheet to find out how many witnesses are in that charge sheet. We don't even have it. But in any event, Your Honor, the process in law is very simple. If they have evidence of him interfering with witnesses, the procedure is very simple. Make an application, come to court. Your Honor, what we're submitting therefore is that all the allegations here in this affidavit appear hearsay, presumptions of what he might do, but has not yet done. In view of that, Your Honor, and in view presumptions of what he must do, and yes, that's what this affidavit is all about. That he might interfere with witnesses, he might run away, but surely, Your Honor, they're all presumptions of what he might do, but he has not yet done. But the court has the power to hold on to his passport, and even most importantly, Your Honor, if they have such great fear, the court can also make an order that apart from depositing the passport, he can be visiting the IO every 2 weeks, just to record his presence in the country. And if he fails to do that, then there's also the legal process, Your Honor, of applying for a warrant of arrest. So, Your Honor, the mechanisms are very many that the DPP can use in the event these fears are realized. But for now, Your Honor, all these fears amount to hearsay and cannot and should not be used to deny him bail. The medical report there raises very serious medical issues. And on the basis of that, we are humbly praying, Your Honor, that you grant very lenient bond terms. We pray that the court should not be guided by the huge figure of $35 million. Because, Your Honor, as this court well knows, one is innocent until proven guilty. Would be putting him and his life at great risk. Secondly, Your Honor, the accused person is a well-known businessman and is not a flight risk, as alleged. That particular concern of the prosecution of him being a flight risk or leaving the country can be very easily addressed by having one of the bond terms being him depositing his passport to this court. That, Your Honor, takes care completely of that issue of him being a flight risk. The next thing, Your Honor, is that he's married, he's a Kenyan, married to a Kenyan, has children in school in Kenya. His roots are here. And therefore, he has no interest whatsoever of being a fugitive. In fact, Your Honor, the cause of all this is the fact that he's at the final stages of acquiring Bamburi Cement, having won the tender for the same, and in an attempt to stop him, these charges have been hurriedly brought in order to stop him in his quest. Your Honor, therefore, somebody who has actually won the tender for purchasing Bamburi Cement is not one who is a flight risk. The other issue that has been raised is that paragraph 16 of that affidavit is that they intend to conduct a search at the residence of the respondent to the view of recovering written documents that are relevant to this matter, and they have indicated that he might interfere with the process. Your Honor, nothing stops. The answer to that issue is very simple. Apply for a warrant, which will obviously be granted. You can do that even this afternoon and go carry out the search that they so wish at his residence. So there's no way detaining him will enhance their chances of finding anything in the house. They can apply for the warrant and go there this afternoon. But it would be wrong, Your Honor, to deny him bail purely because they hurriedly brought him to court without having carried out the prerequisite steps of gathering all the information that they need. And they're now using their failure as a reason to deny him bail. Their failure to do their job adequately. Your Honor, one of the most shocking allegations being made is that the prosecution don't know where the accused lives. I wish to go on record for the court to record that he lives in Karen, on Marist Lane, opposite the waterfront mall. So that takes care of their concern of not knowing where to find him. Karen, Marist Lane, opposite the waterfront mall. He's a well-known personality. If they've done their job very well, by now they'll not be telling because they don't know where he lives. Then, Your Honor, there is allegations. If you look at paragraph 15 of this affidavit, 13, 14, and 15 that relate to money laundering. Your Honor, none of that is in the charge sheet that's been read before this court and should therefore not be used to deny him bail. Your Honor, most importantly, the application to deny bail sounds indefinite. They didn't say they need 2 days, 3 days. It's like he's going to run away, so deny him bail. Your Honor, it is strike law that bail is a constitutional right. If they had said they need a day or 2, it was not done. And perhaps, but nothing of that nature has been indicated by the prosecution in its far too late in the day now for them to even try and reply anything with that. Your Honor, there was also an accusation that he had not disclosed the numbers upon which was found. Your Honor, it was for them to do the investigation. In fact, Your Honor, he did not know he was being investigated. He was just arrested yesterday at Lavington Mall. Your Honor, he has not even recorded a statement and hurriedly brought to this